So.
Anyway,
We're
so see what
recording
you get.
already, huh, Steve?
Nice.
So,
Yes.
let's go ahead and begin. It's 4 o'clock and we have a forum. And then we'll let other people join in as they arrive. So call the order at 4 o'clock. This is the Community Police Oversight Board. I'm Janet Castaños, Chair. And we will start with the Pledge of Allegiance. Caitlin Tiffany will lead us in. Flag is back.
I was about to ask. Okay, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Caitlin. So are there any additions or deletions to the agenda? Hearing none. Are there any public comments at this time, Stacy?
Do not have any public comments or any e-comments at this moment.
Conflict disclosures from anybody on the board about any item on the agenda? Hearing none, I'll move on to current business. The first item on the agenda, 5.1, is the approval of the minutes for the Community Police Oversight Board held Wednesday, June 15th. You all got a copy of those minutes in your packet. And if you've had a chance to look them over, if there are any changes, additions, deletions, please let us know right now. Otherwise, I will ask for a motion to approve.
Move the approval of the minutes of June 15th, 2022.
Second. Thank you. Very Patricia. So Stacy, I will let you go ahead and take the vote.
Board Member Tiffany, how do you vote?
It's not present, so I'll abstain.
Oh, okay. Board Member McWilliams, how do you vote?
Yes.
Board Member Johnson, how do you vote?
Yes.
Board Member Demint, how do you vote? Okay, I'm here. Board Member Darby, how do you vote?
Yes.
Board Member Blackman, how do you vote?
Yes.
Vice Chair Dillard, how do you vote?
Yes.
Chair Castaños, how do you vote?
Yes.
Motion carries with all board members voting yes and board.
Didn't recall all the members.
Oh, I'm sorry.
Nobody wants to be around anyway.
Board Member, Duff, how do you vote?
Yes.
Motion carries with all board members voting yes and board member Tiffany abstaining.
Was Anna Fuentes?
She's not.
Okay, so she's got that. Okay. Thank you. So, 5.2 on the agenda is Chief Sweeney, giving us police department updates.
Thank you, Chair. It's good to see everybody. I want to start off because we have a police officer here that just got off training, and that's Officer Alan Lopez, but he's still on duty. So I want to give him the opportunity to come up first before I give you the rest of my updates. But Alan Lopez, you
Yeah,
just
sir.
come up, introduce yourself to the board.
Yes, sir. Good, my name is Alan Lopez. I've been a police officer here for the city of Mesa for about 7 months now. I got out of the academy on February. Oh, yeah, yes, I got out of the academy on February and started my journey through the field training portion of my training. And I just got off yesterday morning, and yeah, it was a great experience. I've had so many mentors here. There's a lot of people who always offer to help, and I really appreciate every single one of them. The reason I became a police officer here, and I really was, I wanted to work for the city, was because the community of Mesa is a very tight-knit community. Everyone helps each other, and whenever I have the chance, I stop by all the like community meetings, or I'll try and stop by like the neighborhoods and just talk to everyone. And everyone's so kind. Everyone just comes up to you, talks to you, and I always take my time and ask them like, hey, I don't live in this neighborhood. Can you let me know what's going on? Since you guys are the ones that are out here walking and just keeping your eye out, and just taking 1 or 2 minutes out of my time to just talking to people and I really like it. The community is very nice. I enjoy the city, I enjoy the people who work here and live here.
Did you grow up in San Diego County?
I grew up in Chula Vista.
Okay.
Yeah, so I grew up in Chula Vista. I went to school in Chula Vista, and then I attended college. I became a medical assistant, and I did that for about 2 years. I worked with our behavioral health programs, and then also with kids and children and adults with disabilities, autism, everything that falls under like the behavioral health. And then I worked for the orthopedics departments at UCSD. And then I've always wanted to become a police officer, but you know, the parents are like, oh no, it's too dangerous. And I told my mom, I was like, hey, you know, this is something I really want to do. And as soon as I told her that, she's like, if it's what you want to do, go ahead. And every single day she asked me like, hey, what'd you do today? You know, what's going on? It's this person who I go and decompress with and talk to her about everything. And she's #1 supporter, and my whole family is very, very proud of everything. So there's 2 law enforcement officers in the family now. It's me and my brother. So yeah.
Chief, is he old enough?
Yes, we checked his ID.
I'm 26.
All right. Well, thank you, Alan.
It's a pleasure.
Appreciate it.
Congratulations.
Thank you so much.
Yeah, we went to lineup training yesterday at 6:15 in the morning to let him know that he was off training. So it's always a scary feeling. I mean, really? So still got a lot to learn, but he's young, he's motivated, he's excited. And obviously he brings with him some life experience to the career fields that he chose coming up. So very impressive young man. So a couple things on our updates. We've been very busy. This month of August is probably one of the busiest months for us. We started out with the first chat with the chief on August 8th. That went well. For those of you that attended, thank you very much. I thought that was a great venue and it's some great conversation that happened to be able to explain what we've been doing, what's going on, and obviously to answer some questions from the community. We will complete our active shooter training tomorrow. Is the last session that we have. That'll get all of our police officers through that updated active shooter training. I can tell you, I went out to one of them. I couldn't participate, unfortunately, because of my condition right now, but realistic and intense. So what we did is we also had somebody come in and film the responses, and we're going to be working with the schools to share with them what our response looks like so that they can know the same things that we know as far as what we're planning on doing when we come in so that they understand that. So that's going on right now. Yesterday and today we had our autism training that was here at the station. Just a dynamic speaker. His name slipped my mind, I apologize, but Gab's a former law enforcement officer, has a child that's on the spectrum, and he just goes through his trials and tribulations and what officers need to look for, and some of the signs. But just a great presentation overall. So a lot of our officers that may not have had that experience. Brian Herritt, here it is. He's the autism cop. He teaches worldwide. So we're very fortunate to have him come in and do the training. He's still upstairs, so he's been splitting days and nights. So we make sure we get everybody trained, but that's been an exciting training. Tomorrow is our Game Changer event. I think I mentioned that last time. So we're doing the Game Changer event once again. It'll be at the Omni Hotel, where we'll start with the introduction, the pre-survey, and then the mediated discussion. And then from there, they'll go on to watch the Padres hopefully crush the Nationals. And so they'll be able to exchange some more conversation there and just enjoy the game. And then they'll do the post survey once they're done. So we're really looking forward to that. Game Changer stepped up and got us this specifically for La Mesa. So we've got community members and police officers that can't wait to go. So tomorrow at 3:30 it starts.
You have enough community members?
We do. Yeah. As far as our staffing, right now, we're down 2 police officer positions. I think we were still at that same point last time. I've given 3 conditional job officer offers. So we're working to fill in those spots as we go. We just graduated 2 from the police academy. Was it yesterday? Yesterday. There's so much going on. So we just graduated 2 from the police academy yesterday. So we have Grant Pies and Melissa Rodriguez joining us, and they'll go into training. For the female officers, like I mentioned before, that puts us at 21%. So it's a great number to have, 21%. We're shooting for 30 or more. So we'll still work on that goal moving forward. Our diversity levels are absolutely consistent with the city right now. We update that on our website every time we hire somebody new or somebody comes to or leaves the department. We update those numbers. We're down 3 dispatcher positions right now. So we've had 2 police dispatchers, excuse me, 1 left for another agency, unfortunately. And one of our officers we hired as one of our dispatchers we hired as a police officer. So she will go to the academy on August 29th. So we always like to hire from within because we can see what kind of person they are. And Allison Granillo is the new police officer that is starting the academy. So she's really excited. She was fortunate enough to grant us the opportunity to not go to the June Academy because we were short on dispatchers. So she stayed and helped us out. And so now she's going to the August 29th Academy. So we have 1 dispatcher that's going to start, a new dispatcher that's going to start the beginning of September. She's coming from Kansas. She's a lateral dispatcher with some experience. So we're looking forward to getting her here. We'll be testing for our detective position, which right now we're short in detectives, and we've we're playing chess right now, you know, where we need the most and moving people to cover spots so that we can make sure that we have the services available. As I mentioned before, we have quite a few in training still, so that takes away from that full capacity of the police department, but they're all doing well. So knock on wood. We have Clara Baltadano. You met her. Actually, I don't think you met her yet. She's not on training, but she is. She's in training and expected to go into her final phase next week. Matter of fact, she was at that chat with the chief. I introduced her there when she was out with her training officer. Everybody else in training is doing well. We'll have another sergeant assessment center. We have 1 sergeant that just retired. We have another sergeant that's on the bubble to retire, and we have a lieutenant that will retire in December. So that, yeah, a lot of movement, which is good for a small agency because, you know, usually a small agency gets stuck for a while. So we have a lot of good candidates. So we'll be putting in for that. We'll probably be reaching out, we will be reaching out for help for those assessment centers. So as that comes near, I'll get you dates so that you have them on your calendars. And then last but not least, we have our final chat with the chief for August. Will be on August 28th. And that'll be, am I off the date? 25th. Thank you. And that'll be at the community center.
You got one more item?
I do.
Yes. You have the Citizens Academy starting.
We do have the Citizens Academy starting in October 12th. I was gonna save that for the next meeting.
Oh.
That's okay. We got a lot of good stuff. August was just filled with activities. We had a lot of stuff going on, trying to make sure we get the training that we needed to get out of the way. We have a lot of officers that are brand new that need new training. So our staff has been working incredibly hard, a lot of overtime and shifting and doing things, but we've had 2 critical events, obviously, in the last couple of weeks also, which you may have heard of. We had a person that was suicidal and unfortunately took his life in the car while the officers were behind him. So that was fairly traumatic on our officers. And then we had recently a homicide, which we're still investigating, which happened at 9:42 in the morning on University Avenue. So we're hoping to put a bow on that one and move forward here very soon. But a lot of stuff going on in the city of La Mesa, and I'm extremely proud of the officers, dispatchers, and all of our personnel really stepped up to make this happen. So that concludes my updates.
Thank you.
And Chief Sweeney, I just want to recognize that you had a fairly new African-American police officer that you most recently hired as well. So I was happy to see that.
I have two right now that also have conditional job offers. So,
Happy to hear about that.
absolutely.
And Chief, I had a question for you. So with the chat on the 25th, are you gonna have a Zoom option? Because I contacted Lieutenant Lynch about that for the last one. So
We hadn't discussed that. It was gonna be an in-person one. I'll talk to Lieutenant Lynch and find out what she got with.
Yeah, we had about 21 people at the first chat with the chief, and Larry, Bob, and Patricia and I were there, and we handed out the community attitudinal surveys. We collected back 15, so that was pretty good. And we hope to continue to do that at all of the gatherings, whether it's, your chat with the chief, or whether it's theme based, like the forum on homelessness. It's good to just get a sense of how the community perceives the police department and if that's changing over time. And then we'll go back to Helix and get input from the students as well. So yeah, that was really a great night. And then your dispatchers, I just have to say, are really terrific. They do a great job. They explain things thoroughly. They're very patient. And every time I've had to call on some issues in our neighborhood, and they've always been really kind and helpful. And I just wanted to say that I'm impressed. And then I also love the fact that you had mentioned at an earlier meeting how you send out surveys following interactions. And I love the surveys because it's asking similar questions to what we're asking in our attitudinal survey, but it gets to like, what was your experience with this particular instance? So it's very specific. And I love that, being able to answer those questions every time you have something or some interaction with the department.
Thank you. I appreciate that.
And how many people on the board have actually taken part in a Citizens Academy? I think Larry, haven't you?
The first one.
Bob, oh yeah, you were the very first one. So
Annabelle.
I highly recommend that experience because you learn a lot, and they really do a good job of introducing you to all the various aspects of the police department, dispatchers and so forth. And yeah, so if you can fit it in, I think it's 8 sessions.
6.
6, okay, I think I missed one and I didn't get my certification, but they're very, very strict about, but I highly recommend you participate in it. You learn a lot, and it's a great opportunity if you can make the time, but it's once a week on like a Wednesday night or something.
Beginning October 12th.
October 12th.
You will
So
not be bored.
yeah, you will not be bored. There's a lot involved. So great. Thank you, Chief.
Thank you.
Thank you. The next item on the agenda is 5.3, Independent Police Auditor Updates. We have Rick Rasmussen and Dennis Montahano online here on Zoom. Welcome.
We're just finishing up the second quarter report, so that should be good to go here in a week or so. You have the first one already. We have 2 cases that are currently in IA that fit the criteria for audits. So they've been assigned, and we're just waiting for IA to complete that and get them back out. And I think that's about it. Dennis, I miss anything?
You're muted, Dennis.
Yeah, you do have it covered, and yeah, that's nailed it.
And so the historical audits that you're doing, that's in addition to the quarterly reports, am I correct?
The historical audits are completed. The quarterly report reflects what occurred from the end of June through the start of April through June.
I'm talking about historical, so like from the past 10 years.
They're done.
Oh, okay, so you've been working on those. And because our report is just half of those, right? The report we have today.
Tonight, yes.
Great. Any other comments, questions for our IPA? Thank you both. Appreciate your work. We have a presentation from Dale Larson and Caroline Chapetti about confidentiality. So Dale and Caroline, I'll let you take it away.
Sounds good. Stacy or Carlo, is it okay if I share my screen and control the PowerPoint on my end? Will everyone be able to see that?
Yes.
Great. I think I just need permission to share my screen. So I'm going to give a brief presentation on some of the legal obligations for handling confidential information. I'm going to try to keep this pretty brief. We have a lot on the agenda tonight, and our policies and procedures for the board already essentially bake in these confidentiality obligations. So there's not much that you all as members of the board have to independently do to manage confidential information, but we just wanted to give a bit of a refresher to the new members, or give an overview for the new members and a refresher for the rest of you. It's looking like screen sharing is still disabled.
We're working
They
on
just
it.
gave you permission.
Technology. Before this.
Aha, there we go. All right. Success?
Yes.
Yes.
All right. So let me just figure out how to make sure I can see my notes. Okay. So tonight, my goal is just to give a brief overview of how your role on the CPOB involves confidential information, and to give a bit of an overview on the legal restrictions for handling that confidential information. I'm just flashing the relevant section of the municipal code up here, which sets forth the CPOB's powers and duties. I'm not going to read through this tonight, but I'm just making another entreaty to you all when you get a chance to go online to the La Mesa Municipal Code and to read the ordinance, which sets forth all of your powers and duties as a body. And that lays out some of the places where confidentiality concerns might come up. The short answer as for where confidential materials might come up are two places: complaints and audit reports. So state law, as we'll explain shortly, prohibits the sharing of certain information identifying police officers in connection with investigations and complaints. And so that information, those laws affect the extent to which the CPOB is able to view complaints in their entirety and audit reports in their entirety. This slide identifies some of the places where state law and policies provide guidelines and limitations on the sharing of confidential information and the storage of confidential information. The IPA is going to be giving a presentation after this addressing some of the relevant provisions of the Public Safety Officers Procedural Bill of Rights, which is sometimes referred to as POBOR or POBRA for short. I'm going to focus on Penal Code Section 832.7 and the Public Records Act, which set forth what records can be made public and what records are confidential under state law when it comes to police officers. And then the La Mesa Police Department policies provide additional guidance on where and for how long certain police personnel records have to be stored. So I'm just going to flip over this slide relating to POBRA since the IPA will be presenting on this afterwards. So 832.7 is really the important statute for the purpose for a lot of the decisions around what police personnel records can be made public. This statute and a couple of others are frequently referred to as the Pitches statute. So if you, as I do, read a lot of court cases about the handling of confidential police information, these statutes are often referred to as the Pitches statutes for short. And that's the name of one of the cases that delineated these limitations. And these statutes impose limits on the discovery and circulation of certain police records, including personnel records and records of citizen complaints about individual officers and reports or findings related to the investigation of these complaints. So the Pitches statutes, including 832.7, largely prevent the public disclosure of these types of records, but nothing in these statutes prevents the police chief from disclosing those records to the IPA, for instance, in the course of an audit, or to another independent investigation agency, or from disclosing those records to the city manager, who has powers under state law, his own investigatory powers. So that's just to say that these statutes guide what can be released publicly, which is relevant for you all since the CPOB is a legislative body that to which the Brown Act applies. So as you guys may already be familiar, your meetings are public meetings, and that means that anything that you review in connection with the meeting must be made public. So the interaction of the Pitches statutes and the Brown Act explains why confidential information cannot be reviewed in public meeting. Now, this all sounds relatively complicated, I'm sure. You all don't have to worry too much about how to make these sorts of judgment calls. That's what counsel is here for, and that's why we have crafted the policies and procedures and worked with the IPA and Carlo to figure out ways in which information can be shared so that we're not in violation of any of these statutes. So in recent years, the legislature has decided that it is important for some information related to complaints against police officers and investigations to be made public. And it has identified certain kinds of serious incidents where more police records can be made public or can be requested via Public Records Act. Some of those are listed here. They include incidents involving the discharge of a firearm at a person, an incident involving use of force that results in death or great bodily injury, an incident where there's a sustained finding of sexual assault, or a sustained finding of dishonesty by a police officer. In the cases of those incidents, the statute lays out all of the information that can be made publicly available. So you'll see it's quite broad. All of the investigation reports of that incident, evidence, transcripts of interviews, copies of disciplinary records. And last year, you may remember that we, for those of you who were here, the legislature passed another bill amending the statute even further, and they added additional categories of incidents where records can be made public. And these included recording in progress. Cases where there were sustained findings of unreasonable or excessive force, sustained findings of unlawful arrests and searches, and a few other categories. and you'll see them here. So again, the California Records Act also has some things to say about what kinds of documents can be made public. And the Public Records Act largely tracks the penal code, meaning that the categories of police personnel records that we were just talking about under the PICHA statutes can be withheld from a Public Records Act request, except for those exceptions that we just identified. I've added a slide here on La Mesa Police Department policies in case you're curious. These were all available online when I put this together last year. I believe they still should be online if you're curious. And these policies govern how long personnel complaints have to be held on to, and who has them within the police department, that sort of thing. So the Brown Act. So the Brown Act places some constraints on what confidential information can be possessed and discussed by the CPOB, because the CPOB is a legislative body that meets in public, has obligations about obligations to turn over everything that you review and discuss to the public. So this one provision of the Brown Act that prescribes writings distributed to at least a majority of the board in connection with the matter subject to discussion or consideration at an open board meeting are disclosable public records under the Public Records Act and shall be made available upon request without delay. So the takeaway here is if a majority of the board considers a document, that document must be made public. So this statute is the reason why, for instance, the board isn't able to receive and discuss a full unredacted version of an audit report, because that audit report would have to be made public. And if that audit report contained confidential information, then it would be in violation of the PICHA statutes, which I identified earlier. So this is essentially, those two statutes together are the reasons why the audit report has to be scrubbed to remove any sort of confidential identifying information. Now you might ask, why can't we just meet in closed session to discuss confidential information? The Brown Act only allows closed meetings for a few specific instances, including litigation, real estate negotiations, certain sort of personnel decisions. And so there isn't an exception that applies to the discussion of this sort of confidential information.
I would just jump in on that last point and add that even though there's an exception for handling personnel issues and discipline issues, and some of your work touches on those, the cases have made clear that that Brown Act closed session exception can only be used by those who have the authority to impose that discipline on the employees. And in this case, as you all know, that's not within the board's powers.
Thanks, Dale. So what does this all mean in practical terms? This is probably the most important slide. So because of that whole statutory landscape, the board's ability to directly review and consider confidential information, which really just refers to information that would identify a particular officer as the subject of a complaint, or any specific details about who conducted that investigation at the police department, that is limited. And so the way that the board is set up, individual members or ad hoc subcommittee might serve in roles where you encounter confidential information, such as you might be able to, that ad hoc subcommittee that we discussed recently might be able to meet with the IPA to discuss complaints in more detail, or the details of an audit report in more detail. But those discussions and those reports wouldn't be discussed in public session. We've also designed a process where therefore the IPA reviews complaints, and the IPA is the one who prepares and keeps track of what kinds of complaints you're receiving, and offers that information to you in an aggregated format that's digestible for public consumption. And the sort of most important feature, of course, is the IPA, because the board's ability to review and analyze and discuss confidential information is limited. That's why we created this hybrid model, so that there is a person who's able to access confidential information, analyze it, and be the eyes and ears of the board, and then report back to the board in a format that's appropriate for a public meeting under the law. So again, this just reiterates what I just said. The IPA is really the CPOB's eyes and ears, and this model is very useful given the statutory limits on the abilities of a public body to discuss confidential information. So when in doubt, it is unlikely that any of you will be having to make independent judgment calls about what is confidential and what is not. But if you're ever in any doubt about whether information you have can be discussed in public meeting, think about whether it identifies a particular officer, whether it could be part of the officer's personnel file. Those are sort of at the heart and soul of what is confidential. And feel free to consult with me or Dale or the IPA or Carlo or the chair. Any questions? There will not be a pop quiz.
So any clarifications or something, I'm wondering if you were listening to Caroline that you wanted to ask additional information on? Everybody pretty clear? Caroline, I had a question about the instances where they would release confidential information, like the name of the officer, like bodily harm and those items that were mentioned earlier. That's still, that information is not released till the findings have gone through some type of investigation and that's sustained. Is that correct?
Yeah, so there's one provision, I believe, allows the police department to delay providing any information to the public until their own investigation is complete. And there's some categories of information or some kinds of incidents where I believe the information can be subject to a public record request regardless of whether there's a sustained finding. So I think a discharge of a firearm, for instance, and use of force resulting in death or great bodily injury. So those two categories of incidents permit public disclosure of records regardless of whether there's ultimately a sustained finding against that officer. But I believe that the police department is entitled to not turn over records until their own investigation is complete. In these other categories, you're correct that there has to have been a sustained finding by the law enforcement agency under their own investigation process. But once there is that sustained finding, then someone could file a public records request and access that information.
Thank you. And is this only true for from here on out, since this item is passed, or does it also include historical items?
That's a good question. I'm I believe that there might have been a limited retroactive period, perhaps the beginning of 2022 or 2021. This was passed in fall of 2021, and there might have been a very limited period of retroactivity, but I would have to look back at that, but it's not generally retroactive.
Thank you.
And yeah, Caroline, I just had a question. It really doesn't, I don't think, relate to the CPOB, but is there a policy, and maybe Chief Sweeney can answer this, but I'm thinking that you can. If you have police officers on site with an incident, and are police officers allowed to take pictures or photos with their personal phone camera outside the responsibility of the police department? And if there is a witness that states that, is that against the law, or is that a policy that would be broken by the police department?
Chief Sweeney, you might have a better idea if there's a policy against that. I'm not aware of any.
There's no law that I'm aware of, and there's no policy that we have that says that they can't do that. If they take evidentiary photos, then those need to be impounded just like they would with a department cell phone.
What if those, what if some of those photos got out to the public? Because maybe it was a well-known figure or something like that that happened.
That would end up being an internal affairs investigation if that was the case.
Okay. Thank you.
Are there any other questions or any public comments or questions on?
And just so I'm clear, you're talking about like the Kobe Bryant.
Yeah,
things of that
that's,
nature.
yeah, I mean, there were some police officers or somebody that took pictures and ended up, selling them to
Yeah,
make
there's a
money
couple
off the
horrific
dead
cases out there.
body.
Yeah. CHP had one that was pretty horrific, and then the LA. So, yeah, those all, I mean, if those get out, that they're active investigations and they get passed along personal lines, then that's an internal affairs investigation.
Thank you.
Thank you. I'm glad Michaela's here to listen, because she's one of our new members, and Danny Walkup and Kristen Dement will be, if we could send them the video recording of this meeting, it'd be great for them to have this in service as well. So we'll make sure we do that. So thank you, Caroline, for that information.
You're welcome.
So the next item on the agenda is report, a presentation from our independent police auditor regarding public safety officers bill of procedural bill of rights, POBR. Rick Rasmussen and Dennis Matahana.
Well, hello, everyone. I hope everybody's having a good day over there. Is the weather good over there? Because it's 109 over here, so I'm thinking it's probably better. Yeah, probably has to be better. I'm going to share my screen, so let's see. I'm disabled from sharing, so yeah, if you can allow me to share, I'll bring up a screen here real quick. And this is going to go fairly quick. I know most of you have sat through this presentation before, but for the new folks, and as a reminder to everybody else, the basic rights of police officers as they relate to personnel actions. And so we're going to kind of do the nice overview of that. And let me see here if I can share now. And I can, so let me find my deal. And there we go. We go full screen. Try and go full screen. There we go. Okay. So what we're going to be talking about is commonly known as POBR. And that's just commonly how it's referred to, but it's really encapsulated in the government code. And it's been long-standing. This is something that the first Governor Brown signed into law, or I'm sorry, Jerry Brown, not the first, but Jerry Brown signed into law in his first term. Anyway, it does apply to police officers, deputies, and for our purposes, police officers are what we want to know. Now, interestingly, it doesn't apply to reserve police officers, but most agencies decide to afford their reserve police officers the same status and same protection. So while they're not obligated to, most agencies do so anyway. It also applies to any off-duty conduct. So if an officer gets in an incident and it potentially could violate a department policy, for example, a criminal act, they are certainly subject to the provisions of that department's policies, both on and off duty. And so we're going to talk briefly about allegations of misconduct. They generally are going to result in some sort of review. If it looks like it's a really nothing deal and there's nothing that's going to be gained out of a full-blown investigation, it's still going to be handled. It may be something as simple as, well, I shouldn't say simple, but it happens from time to time. An officer's been working nights, they've been in court all day, the baby's been crying, and they fall asleep in their car because it's a particularly slow night. Sergeant pulls up and says, hey, buddy, wake up. And, you know, you can't be doing that. I don't want to see that again. If you do, it's going to result in something more serious. It could be as simple as that. It could be full blown if this guy keeps sleeping on duty. So it's really going to depend on a lot on what the department has seen from an individual on some of these minor things. If it's something more serious, like a complaint about racism, excessive force, dishonesty, it's going to generate an IA right off the bat. The department's going to take those allegations very seriously. And one question that comes up a lot is, how about an anonymous complaint? It depends, just like on everything else. What information do we have? Do we have enough information to investigate this? And if the department does, they're going to. Because remember, the bottom line to all of this is the department wants to ensure that their officers are doing the work that they want them to do in the manner that they want them to, in a way that promotes trust in the community. And if an officer isn't doing that, then they're going to want to look at that and deal with that. If it's a relatively minor thing, you know, counseling, oftentimes it's going to be training that comes up, you know, during the officer's evaluation. They may note that the officer failed to dust for fingerprints at a crime scene when they should have. And so that could come up in their evaluation. Trust me, the officer's going to remember that. And that's the goal of discipline, right? Especially in minor deals, is to get that officer to comply with the department's rules. And so they do their job correctly. But, you know, and it'll result, if you have a situation where the facts aren't in dispute, there's not a lot of big problems with it, that's what you're generally going to see. But if it's a major deal, like any of these right here, are going to result in some sort of investigation. And they're going to trigger a response from the IPA as well, in terms of reviewing how the department handles that. Right now in the pending quarterly report, which you'll see that we have a couple that we're going to be looking at through the audit process for just how the department dealt with it. And we don't make that judgment, of course, in terms of you should have done this or that, you know, unless it's something rather obvious, but we're going to make sure they dotted the I's and crossed the T's, and that's generally what we've seen. So that I wouldn't be surprised to see we continue to see that. Now, when you have an allegation of misconduct, the reason I wanted to make sure you understand is there's a lot of levels of what can happen and what constitutes disciplinary action. It's also punitive action. Here you can see that counseling, that's not on the list. Training, that's not on the list. But if it's going to involve these sorts of things, that means that generally that employee has rights that kick in, and those rights include the Peace Officer Bill of Rights. So if the allegation is investigated and could result in a letter of reprimand, a demotion, a termination, those rights kick in. And that's important to have that. If there's a criminal allegation, and these come up from time to time, you know, it could be something very serious, like theft, excessive force that rises to a criminal level. I mean, these things can happen, and we've seen that, you know, in other agencies around the nation. And so it's going to result in it's going to result in both an internal affairs investigation and a criminal investigation. Now, here's the difference. If I have an officer that's charged with a very serious criminal act, let's say they're charged with providing confidential information to gang members, serious charge. We're going to have a criminal investigation that takes place, and the criminal investigators are going to contact that officer and say, we would like to talk to you. We want to get a statement from you. And that officer says, you know what? I talked to my attorney. He said, I probably shouldn't talk to you, so I'm not going to talk to you. I'm invoking my Fifth Amendment rights. Perfectly legal to do, absolutely guaranteed that right. The internal affairs investigator contacts that officer, says, I'd like to talk to you. And the officer says, well, I really don't want to talk to you. I want to have my Fifth Amendment rights. The internal affairs investigator is going to say, yeah, I get that. And in fact, I'm going to read you your rights. And then you can tell me that you refuse to speak to me in violation of your Fifth Amendment rights. But then what I'm going to do is tell you that under the case of lie barter, which is a personnel action, you must still answer all of my questions, because if you don't, then you face the threat of disciplinary action for not following my order to discuss this. And in most cases, that means termination. The officers understand that if you don't talk to IA, you're going to get fired. And so they're compelled to talk to you. Now, what's important to note is then when they're compelled to talk to you, those statements receive immunity. In other words, they cannot be used against them in a criminal proceeding, but they're wide open for that disciplinary action. Okay. Now, the officer can review, they can record their own interrogation. IA will record it. And if the officer needs a copy of that, their interrogations recording, they'll just simply provide it to that officer. But the officer can also record their interrogation. They certainly have a right to representation. Most folks do, and not just in policing, but anytime you have an organized workforce, you're going to have that right to have a representative there with you. In most cases, officers have another officer with them that has some training in this. And it's just to ensure that the officer's rights aren't violated. They're not there to present evidence in their behalf. They're not there to act as like an attorney might on television. It's there to ensure the officer's rights are not violated. Another question that comes up a lot is, well, let's have this guy take a lie detector test. I mean, if they didn't do it, that'll show it, right? Well, the problem with that is lie detector tests or polygraph exams are not admissible in court generally. And what you're going to find is the officer isn't compelled to take one. In fact, if the discussion comes up and the officer says, no, I'm not going to take it, you cannot even indicate that in the report. So that's kind of what the legislature did on that is they're making a pretty strong statement that we're not going to recognize polygraphs as admissible evidence, even in an administrative hearing. Okay, so what happens after that investigation is done? Well, the report's complete. The investigator is going to come up with a finding. Exonerated means the act happened, but the act was within policy. So whatever the officer did or is alleged to have done, yeah, it happened. And oftentimes we see this in an excessive force allegation. Yeah, the officer tasered them. The officer leg swept them and causing them to fall to the ground. But there was a reason for it, a valid reason for it. If we come up with an unfounded, that means the act didn't happen. So in other words, the person says the officer used excessive force and the video shows there was no force used at all. That's going to be unfounded. And then we have sustained, and that means the act occurred and it was a violation of that department's policy. Okay. And when we establish that, it's not like, on Law and Order where they have to prove beyond a reasonable doubt. Just like all administrative actions, it has to simply be more likely than not that the officer committed the policy violation, a preponderance. And then finally, not sustained, which you're not probably going to see very much of, means we couldn't figure it out. It's a wash. We can't develop enough evidence to go slightly more this way or slightly more that way. And as a result, it's a not sustained. It happens once in a while, but it's pretty rare to see that happen. Because if an investigator's leaning that way, generally, they just need to dig more. They need to find more, keep digging until they are able to tip that scale. Once that investigation is complete, the findings are entered, that case goes to the chief of police. And the chief of police has wide latitude on how the chief wants to handle the case. For example, the chief can agree with the findings or disagree with the findings of the investigator. That's the chief's prerogative. The chief could say, you know what, I've still got a couple of questions here and I want to send it back for more investigation. It goes back to the IA takes a look at that and tries to answer the chief's questions and then sends it back to the chief. When the chief agrees with the allegations of sustained findings or says, you know what, IA investigator said exonerated, but in my review, I'm sustaining it because the chief has that authority, The chief will then decide what disciplinary or corrective action they want to impose. And it's going to be action that is going to be recognizing the significance of the violation. Is there an opportunity to retrain the employee, to salvage the employee, or is the case so significant that it requires termination? The chief's going to make that decision. Once that happens, the chief is going to tell the officer, or the department's going to notify the officer that there is a pending action. So in other words, the chief reads the report, agrees that there's a sustained finding, and decides, I'm going to give this employee a 5-day suspension. That's pretty significant. That's a week's pay. The officer gets this notice and says, whoa, wait a second, I don't think that's right, or I don't think everything was done, or whatever reason. They have a right to what's called a pre-disciplinary meeting. It's known in California as a Skelly hearing. At that meeting, they can bring forth mitigation. What happens oftentimes is the officer will come and say, yes, chief, I did do that, but here's kind of why I did it. Here's why you might kind of hopefully understand. A lot of times the officer just comes and says, I did it, chief. I want you to understand that's not how I normally do business. Sorry I did that. You won't have to worry about that again. But it's a great opportunity for the employee to meet with the department head and restore the employee. I mean, that's what we want. We want to make sure that the disciplinary process gets that employee back on track, continues. We continue to have a really good employee, not somebody who's bitter and upset with the agency and doesn't do a good job. So that's it in a nutshell. Just recognize they do have certain rights, but the departments, for everything we've seen at La Mesa, they are dialed in on understanding and protecting those rights, while at the same time conducting very thorough, complete investigation. So you've got a good mix going on right there. Any questions with anybody?
Questions do you have?
Okay, I'm going to stop sharing here. And there you go.
It was an excellent presentation. Thank you, Dennis.
You're welcome.
And if we have any questions in the future, we will probably come to you. You're our expert. Any further comments or public comments?
No public comments.
So let's move on to 5.6, report from the independent police auditor regarding historical cases. You've all received a copy of the historical cases that they've been working on, and you've had a chance to look them over. And I think Rick Rasmussen is going to present this information.
That's correct. So the first case, my understanding that we're going to look at is 2018-07. If we're all good to go, we'll start on that one. As you can see from the summary, this was a early morning stop at the trolley station where the officer was responding to a reported suspicious person. During the interaction, the complainant became agitated, yelled at the officers, called them derogatory terms, which is pretty standard. The complaint was then handcuffed, taken, and seated on a bench. The officers cited them via a ticket, not having a valid ticket for the trolley. That's against the rules there, almost like a loitering type of thing. And the complainant began to complain of an injury. The officer wasn't immediately responsive, and the basis of the citizen's complaint was that they delayed or denied medical treatment. Eventually, the officer called for medical assistance. We'll get to the reason why later. The 3 policy standards obviously is listed: use of force, courtesy and civility, and performance. This case was really straightforward, and it was straightforward because there was a video. In the video, you could see the actions of the officers, and they didn't comport to the reported actions of the officers from the complainant. The officers both appeared to be very calm. There was no raised voices, profanity, name calling. Other than the complainant, who was noted in the IA review as being agitated, there was really nothing outside the ordinary, which we wouldn't expect. So in this case, as we reviewed it, we found that the IA had done a thorough and complete examination of the facts. We agreed with their finding that there was no improper use of force, nor did we believe that, based on the evidence, that you needed to summon medical service for the complaints about being handcuffed. So it was pretty straightforward. It was fairly well handled, and we just want, and we made a recommendation on this, that we wanted the PD to review and make it crystal clear to their officers when they needed to summon medical care and when they could use officer discretion. Any questions on that one?
What questions do you have? Can I just ask, at the beginning, when the complainant was handcuffed, was the original handcuffing because of public disturbance or because of the trolley ticket, or both?
Yeah, it was most likely both. I mean, obviously, at 4:30 in the morning, when you have even a minor violation, it does cause officers to be more careful, and without an unreasonable delay, there's a thing called an investigative detention, generally accepted to be up to 30 or so minutes according to case law. And during that investigative detention, the officer is authorized to place the subject into handcuffs if they so desire. Now, handcuffs by definition are uncomfortable. They hurt those little bones if you move around. In most cases, if you look at videos, once an officer applies the handcuffs, you'll also see them stick their finger between the handcuff and the back of the wrist. And if they do that, then they check to make sure that the handcuff isn't too tight. And they'll also do a thing called double locking, where they push a little button, and that way the arrested party can't tighten nor loosen the handcuff.
So on the top of the second page, or in our copy, page 49, it's at the very top line, it says thereafter S2 arrested C, and then arrested C for delaying and obstructing an officer. So I wonder if you can indicate where it says S2, the officer arrested C, if you could put for what reason C was arrested initially, and then it says, and then arrested C for delaying and obstructing an officer. So it's like it's just not clear why the complainant was arrested initially. And I just thought if that could be put in this.
I think it was covered, Janet, in that they stopped him and initially cited him for failure to have a ticket as per the local restrictions at that time at that location. That was the citation. And then he ended up, rather than just being cited, which is an infraction versus a misdemeanor, he was then arrested for delaying and obstructing an officer. And that comes exactly from the IA report.
Okay, so that sentence is still, it's not clear to me. And it says thereafter S2, or the officer, arrested C, and then arrested C, or complainant, for delaying and obstructing an officer. So all I'm trying to get at is the officer arrested C. Is there any way you could put in, you know, public disturbance or whatever, you know, I don't know, and maybe you don't know either. I don't know why it has to be said twice. The officer arrested C and then arrested C for delaying and obstructing an officer.
Yeah, I'm not sure why the language was used that way in the IA report. Remember, we're auditing their report. We're not writing the investigative report on our own. So I think we just chose to use the language that the officer used in his report, and it didn't strike us as unwieldy in our review, but henceforth, we'll try to make it a little clearer.
Okay, thanks.
You're welcome.
So on page 50, the second paragraph, there's a confusing sentence kind of in the middle that starts, Lieutenant L1's report noted that S2 had a very relaxed pace while walking towards the complainant, and that complainant stood in a relaxed and non-threatening interview posture while interacting with complainant. I think
Tell me the page again.
it's page 50, the second paragraph, the sentence in the middle that starts Lieutenant L1's report.
Okay, I have each report broken up, so I don't have a page 50. On this particular report, second, third, where are you?
Page 3, top.
Okay,
Top of page 3, second, I mean, just the first full paragraph, I guess. It just seems as though the second use of C or complainant should be S2. It's just not making sense.
okay,
So check that out.
okay. No, he's speaking, the IA lieutenant is speaking about the way subject officer number 2 walked towards the citizen. And so he says, his report noted that S2 had a very relaxed pace while walking towards C, and that C stood in a relaxed, non-threatening interviewing posture while, okay, I got you. I see it there.
Okay.
Yeah, that should probably be the officer S2.
It is.
Yeah.
Yeah. That's what I figured. Okay. So, and just out of curiosity, and maybe the chief might weigh in on this, what sort of discretion is the officer allowed in determining when medical assistance, or does that have to be, according to your recommendation, more clearly spelled out in the policies or procedures? Is there a leeway? I mean, I would think, you know, obviously the officers did the right thing. There was nothing wrong, and that was confirmed. And officers don't want to spend a lot of taxpayer money bringing in. Yet, what sort of discretion does the officer have? Because some people might, I mean, we've seen national reports where people should have called for help.
I think there's a big difference here between somebody coming back to the station that we arrested and saying I'm having chest pains. The officer needs to call because we're now responsible for that person. If they're out there, we were talking to them, they're saying they're having chest pains, yeah, we're gonna call an ambulance to come and check them out because that's not our expertise.
Yeah.
In this instance, the way I read it, and I don't recall the whole thing, but the incident was over, handcuffs were off, and he says, I want you to call the paramedics. And the officer, I'm not gonna call the paramedics, why? So,
Yeah, I mean.
and then this gentleman called 911 and called and asked for the paramedics and just kind of got it rolling again.
So, yeah.
But in that instance, we wouldn't expect our officers, it's not a medical emergency.
Right.
And if somebody's complaining about wrist pain, you can go to the doctor. Or you can call an ambulance and, you know, if you want to pay the medical bill, that's which
Yeah,
I don't think anybody does.
so there is some discretion.
There is discretion,
Yes.
yes.
Any other questions, comments on this first case? Okay, Rick, I think we're ready for the next one.
Okay, let me get to it. Switching screens, which I am not good at. The second one is C19004. This case is, again, this one is fairly straightforward. In the middle of the afternoon, a speeder was noted by the officer going well in excess of the 35-mile-hour limit, going 57, which I think, yeah, that's pretty good. 22 over in what is an otherwise quasi-residential neighborhood. They initiated a traffic stop that went as normal, and both officers initiated the body-worn cameras from the time of contact until it was complete, which is something we always look for. The driver was cited and eventually drove away. Later, the citizen claimed or made a complaint that Officer 1 was verbally abusive towards the complainant and harassed her, that Officer 1 was rude and disrespectful, that Officer 1 was racist and profiled the complainant, and finally, that Officer 1 used excessive force. The body-worn cameras did not verify any of those actions. First, it's pretty straightforward that that the officers kept their cool. They did not raise their voices. There was no examples or intimations that this traffic stop was based on anything other than action, which was 57 and a 35. So, you know, that seems pretty straightforward for the reason to pull them over. We did find that that the officers the internal affairs should have interviewed both the subject officer and the complainant. Now, obviously, the complainants are a little bit more difficult, but it's important to remember we made a recommendation of such. It's important to remember that complainants don't have to come in. They don't have to cooperate. They can file their complaint and go on the four corners of that piece of paper with a complaint. But it's always better to get perspective when you're looking at body cameras on what wasn't captured by the body cameras outside the field of view or anything like that. And in this case, that didn't occur. And so we made a recommendation, which the police department, I believe, has acted on and has, you know, become general policy that they're going to attempt to interview both the subject officer and the complainant, if possible.
And Rick, if I could jump in here for just a minute, you know, another basis for that recommendation was when a person files a complaint, oftentimes they're upset. Their perspectives of the situation can be a little skewed. And this person may have really thought these things happen, even though the body-worn camera shows up something different. So it's important that the department, a supervisor from the department, contacts that complainant so that the complainant knows that something is being done, that their complaint is being handled, and potentially share that information at some point with them. But the most important part of that was making sure the citizen didn't feel like they made the complaint and then it was just simply ignored because nobody ever contacted them.
Well said. Any other questions on that?
Any questions or concerns? I of course, sorry. I'm just confused by the use of W-2 because it's not listed in the parties W2 may be I2, but that person is mentioned a couple of times on page 1 and page 4 of this report, of this particular report. So W2, I think is supposed to be I2, and I just want to get that clarified. So in the final version that's placed online, everybody knows who that person is.
Yeah, I agree with you. We had a lot of help redacting these reports and changing them around. So this first time through, I would expect some minor faux pas like you pointed out. So we'll make sure that we get with the appropriate people and get that cleared up.
And I also want to say, really good job on these reports. They're really well done. So thank you for that. Any other questions on this second report? Or audit, I should say. Okay, Rick, I think we're ready for the third one.
All right, getting to it. I have 2019-08. This was a domestic violence TRO issue. And it's a little bit unusual in that the male party complained that his wife was in violation of the TRO. The investigation was captured completely by the responding officers, and they were able to determine that there was a TRO in place on the wife and that she should not have been at the property. Additionally, they learned later, initially when they got there, she was loud, obviously irate, and I think the officer said smelled of alcohol. So not unusual in these types of cases. In fact, I don't know, probably more usual than not. Evidently, she had had a bad day at work earlier and came home, got in a dispute with her husband, and the officers arrived, separated both parties, took their statements, recorded it, and confirmed a valid TRO was in place.
So Rick, let me just interject here. Could you use the term temporary restraining order just because this is a public meeting?
Yeah, I think I did, but I'll use it exclusively.
You
There
used
was-
it. Yeah, you definitely used it in your write-up, so thank you for that.
The temporary restraining order was violated and California law mandates an arrest. So the female party, the complainant, was arrested and placed into handcuffs and led towards the police car. Body camera indicates that she tried to jerk away from the officer, and the officer responded by grasping her upper arm while he was escorting her to the car and put her in the patrol car, all captured on the body-worn camera. She was then issued her Miranda rights. She opted not to make a statement. The officer stopped questioning her, took her to the jail, and while booking a subject into the jail, there's certain information you need to get unless you want to book the person as a Jane or John Doe. And if you do so, that is really not the way the arrested party wants it to go, because they'll lock you up as a Jane and John Doe until you finally identify yourself, and then you'll start over for the original arrest. So in this case, she confused the Miranda warnings, which preclude officers from questioning an individual about an alleged criminal act, with providing basic identifying information. Pretty standard, happens, but those are her two complaints. One, that once again, handcuffs were on her wrist too tightly, and the second one, that the officer forced her to violate her right to remain silent. So the law is very clear on the latter. And as we discussed in the earlier case about the handcuffs, the officer is checks them. And, you know, I'll just tell you, when you're handcuffed behind your back, sitting in the back of the police car, your body weight shifts, your hands get pushed into the rear of the seat. They are uncomfortable. But I think one of the parts she had is that previously she'd been double cuffed. That's wherein they use 2 sets of handcuffs to make the gap between the wrists larger, but still secure. They eventually did that once they got her away from the crisis site. And, you know, the time is fairly well laid out. So we felt that the investigation was thorough. They left no stone unturned, and that the conclusion that they arrived at, we concurred with.
Any questions? Thank you for that. Nice job.
Thank you.
On to the fourth one.
Yeah, I'm getting there.
Okay.
The fourth one we have is 1347, which is a firearm discharge by an officer. We examined this case in real detail because it's very unusual. But again, at 03:30 in the morning in January, officers respond to a domestic disturbance, and as they're approaching in an alleyway, they notice a parked vehicle pointing at them. 2 officers. The subject officer, there's 2 of them, one's the subject, one is W1. The subject officer hears the car begin to start its engine and accelerate towards him. He draws his weapon because he said very clearly that he felt his life and the life of his partner were in danger, did not have a place that he felt he could retreat in the narrow alleyway where he would not be subject to being struck by the car. So he does issue a verbal command, which I think we all know in a vehicle with a revving engine was most likely not heard by the driver. But in any case, the officer verbalized his concern about the life of himself and his partner being at risk of death or serious bodily injury. So at which time he drew his weapon from a holster that was somewhat unfamiliar to him. Again, it's early in the morning, it's pitch black, and as he draws the weapon much past what we would call low ready, he obviously had his finger on the trigger and he fired his weapon into the ground. He immediately notifies his partner that he has accidentally discharged his weapon. And in the police parlance, this is what's known as a accidental discharge or an AD. They're not unheard of. However, they are fairly uncommon. When the round went off, the car stopped and they were able to resolve the situation. So because it was a discharge of a firearm, it was a case that was in a murky area of the then enforced La Mesa Police Department policy and procedures. It has since been corrected, as we noted in the report. If this were to occur in the future, it would have triggered an immediate response, as all officer-involved shootings do. And so their policy and procedures have been updated. And if this circumstance were to happen again, it would be handled just as if the officer had actually shot at the citizen. We concurred with their findings.
Good
Any
question.
questions?
So, even with the legislation that's changed, from reasonableness standard to necessity in terms of threat to their lives, I guess if a car's coming after somebody, coming towards somebody, they would consider that a threat to their safety.
Not necessarily.
Okay, so give us more information.
Well, I can give you a couple, it's generally prohibited in our policies. So obviously we want our officers, you can get out of the way, get out of the way.
Okay,
That's the more safe thing to do. But I think as Rick had just mentioned in this case, there was nowhere to go.
Oh.
So in those cases, we want to protect ourselves. And then we expect our officers to make a reasonable decision that's necessary in those instances. This was 2013, however.
so probably if this happened today, probably would be the same outcome.
Well, it was a discharge.
Oh, yeah, actually.
So, it wouldn't be shooting at a person. Didn't get there yet.
Yeah.
But the weapon went off before it even got to that silhouette of a car.
Yeah.
So that would be the accidental discharge that we would look at.
An accidental discharge still may have saved serious bodily injury because the car stopped.
Correct, yeah.
So
But
And we don't want accidental discharges any more than the deadly force policy allows for warning shots. And I'm pretty sure La Mesa doesn't allow shooting at moving vehicles unless your life's in danger. So, yeah, you're right. The accidental discharge may have saved somebody's life.
So, on the bottom of page 2 of this audit, there's a reference to Detective D1, which is not listed as part of the list of parties. So I just want, if you could add that, that'd be great.
Absolutely.
Thanks.
By the way, I'll just note that most of these redactions were done on our side, so I take the blame for these redaction issues.
Oh, okay.
I didn't give you up.
And then there's just a couple of like OIS or CAD, and I just circled them, but I will get back to you about, there's a few things, just minor things that it'd be nice not to have acronyms, and since this is going to be posted on our website, it'd be great to have completely comprehensible to the general public type of material. So we're taking out all acronyms. But this report is excellent. And I want to commend both you and Dennis and Dale and Caroline and whoever else worked on it. It's really very, very well done. Thank you.
Is there another case that I'm supposed to brief?
That's pretty much, you've got these 4 that we're looking at today. So you might be working on another one, but it's not in our agenda packet.
Right, we have 5 more that are undergoing the redaction process.
Okay. Very good. Dale's done. All right. Any other comments? No public comment? No public comment. Great. We'll move on to item number 6, and this is a report out from the subcommittees. And Leroy, you have a report regarding the ad hoc committee on developing a mediation plan.
Yeah, I'd like to read some of that, and then I'll have Caitlin come in with some items. And we met with the POA on, I believe I had the dates were August 10, and we had a great meeting. I thought it was really constructive. I thought we got a lot of great information and a lot of smoothing things out. I was thinking of coming up with some really good notes. I got great notes from Officer Wilson, who was fantastic at the meeting, to say the least, right? So let me just cover some of the things that were productive. The working document that we put together, we had input from Janet, Caitlin, Larry, myself. I'm probably skipping 2 or 3 people, but we had lots of input from Dennis, Rick. We had lots of input to put that together. So it was a well thought out document, and the POA kind of like that, but we're looking at that actual format. That's the Lexipol format that works with the city of Pasadena. And I think most of us agree that that will be the format that the final product would put into place with. So that was really a good one. The next concern of the CPO of the POA about the CPOB's continuous push to want to advertise how to complain. I'm the guilty party. I'm the guy who wants to have people have a more transparent complaint process. So I'm just not so sure that it's visible to everybody because we have something on our website that's stuck away somewhere. So that's me. But the POA felt that that was pushing things in too far a direction. So we had a really good conversation, Caitlin and I, the 2 POA members, you 2 were both there. We had a really great conversation, and what we need to work on is something that's going to fit for all of us. I kept making the point to the POA members that they're part of our ad hoc committee, subcommittee, and that we all need to agree on what we come up with. So, so we'll come up with some kind of agreement there. This was an issue that there had been prior meetings for the CPOB to solicit commendations for officers. And the POA would like us to follow through and actually have something on our website that does commendations for officers. So we don't have anything now, but we're going to have something soon because it's not going to be too hard for us to put that in place. And that makes a lot of sense. It was something that the CPOB had talked about doing in the future and that the POA would like to see happening. The POA also wanted to make sure that we were keeping the process and the movement of the whole mediation kind of in a slow movement, right? We need to, I'm reading from Officer Wilson's email. We need to get buy-in from our officers, and the only way to do that is to season the process with positives. And I think all of us agree on that. I think we all have to have a process that moves at a speed that everybody feels comfortable with. This next piece I hadn't really considered, but I was glad to have it as part of the conversation, that officers are concerned about their safety during a potential mediation session. And of course, I'm not thinking that. I'm not the one in the mediation session, but that'll have to be something that we look at to have officer safety, be a paramount piece. The POA, along with the CPOB, if we had the meeting with Rick and we discussed it, that we want to use the IPA's mediator, somebody who's got a lot of experience doing the mediation, and the POA kind of agrees with that. The next one is concerns about the NDA, non-disclosure agreement, and how possibly that could affect an officer with a withdrawn mediation complaint that goes to that Pasadena policy 1022.6F. I read it over quite a few times. We're going to have to involve some other people in that, but it's a valid concern, and we'll have to look closely at that. So we'll make sure everybody gets these. And the last piece, that mediation should only be for procedure, service, and courtesy complaints. And I think we all kind of agree on that.
Yeah, I mean, you basically covered everything. I think the general gist of it was the POA members we were talking to thought that mediation seemed like a positive thing. They had done research on it as well and found that police officers also had positive experiences with it. And so they were happy with the direction we were going, but wanted to make sure that everybody feels like they're heard and can feel good about what we're doing moving forward. And so I thought that it would be nice if we do get working on that commendation, because we all agreed like that sounds great, but then we didn't do anything about it. So I don't know how we proceed with that. Do we vote as a board to direct the city to like create a commendation form?
We have one, right? You have one posted on your website, the commendation.
On our website.
On theirs, but not on ours.
Oh, so would we want to use theirs, or you're talking about something different?
No, I
Talking about
assume
just
we
adding
can
a
just,
piece on
yeah,
there.
yeah.
Use what they have,
Yeah. we can
put it also on the.
And then
CPOB
I think they
website.
just want to make sure that when we're saying, here's the complaint process, like
Yeah.
also if you happen to have like a great encounter, then you can also do this and say, hey, I had a really good time with this experience, so please tell that officer good job and give them a gold star. So
Yeah, we can just ask that it be placed on, because I think that's a great idea too. I don't think anybody would object to have the commendation form placed with the complaint. Right.
Yeah.
I thought we'd already agreed to do that months ago.
we had, but I think it just hadn't like really, I mean,
Yeah.
the chief had made the form, but it didn't,
Yeah.
other than being on the police website, it
Right.
wasn't on ours and
I
it
think
wasn't like being promoted.
Yeah.
So I think that's something that we have to show some good faith and get that out there.
Anything else about that? Oh, I guess the question is, when do you expect to bring it forward with POA's approval to this body?
We're gonna have to meet again with the POA. We'll set up some date to do that. We'll have the ad hoc subcommittee meeting again with the POA.
Okay.
I don't think Yeah, I don't think the POA wanted to put a deadline on it.
Okay.
They wanted to take time.
Yeah, because they need to run it by their officers and find out, yeah.
They will.
what-
Give me a phone call to double check.
Yeah.
Okay, so, yeah, we'll just let us know how it's coming.
Yeah.
Maybe each meeting you can report out about how that's moving
Yeah.
forward.
No, I think it's, one thing that I was thinking it's related to it would be to have some sort of training once we get everything agreed on by the IPA's mediator. So I'm sure Rick and Dennis are thinking that in the future, and that's one of the final steps.
Yeah. Good work. Thank you for that, all the work. For everybody on that committee. Or subcommittee or ad hoc committee. And I just wanted to say, as far as the community outreach group, we're continuing, to gather the surveys, as I mentioned earlier, about attitudes of the community. So we will work with San Diego State once we've collected adequate number and move forward to see, but one of the findings, as the chief mentioned, as chat with the chief, was that the community isn't really knowledgeable about where to find the complaint form. And he made a really good job of explaining to everybody how they could find that form and the fact that it's right next to the commendation form. And so he made that very clear to the public, and everybody felt comfortable being able to find it. It's on the front page, you can't miss it. So that was really helpful. So thank you for that. And then
If I can just add a piece of that, since we're recording,
yes,
is that I think it's important that if anybody has a complaint against one of our, any police officer in this county, they can talk to a supervisor on scene, they can ask for a supervisor on scene. They can come into the police department, they can get a complaint form here and speak to a supervisor, they can go over to the city hall, they can get a complaint form. And the best thing is you can Google, how do I file a complaint on La Mesa Police? That's the second thing that comes up, right to our website. I don't know that you'll get that same thing with every other police agency in the county,
Yeah.
but you get it with us. So it is, in my opinion, a very simple process to find out how to file a complaint.
that's transparency. Thank you.
You bet.
That could be
Yeah.
wrong. Great. Well, thank you all for that. I know Larry's, in terms of staff and board member announcement, Larry's getting ready for NAPO, aren't you, in September? And so you've got your classes picked out. We're hoping you bring information back and share it with us.
Be happy to.
Right? And then any of us can attend online sessions. There's some in October, November, and December, series of sessions. The first one in October is all about creating an oversight board. So we're kind of past that, but the one on November 2nd is about establishing and supporting effective reform efforts. And then November 9th about maximizing your agency's potential. So we can send this information out. I think Lynn, we can get this information to you, which has the courses, and you can let him know if you're interested in attending on any of those days. Again, it'd be great if you could bring that information back and share it with all of us. Other reports or comments by any board members or staff? All right. With that, we will adjourn at 5:41, and our next meeting is September 21st. See you then.